Further hearing in the appeal Williams and another against London Borough of Hackney.
Mr. Stewart.
My ladies, my lords, we'd like to start the day with subsection 8 of section 20.
Very good place to start.
In fact, although it'd be a risky challenge to this court to say, try to stop us because we're determined. But anyway, yesterday's, first of all, supplement yesterday's submission that the section 20 subsection 8 right couldn't be exercised while the bail conditions were in force. And we'd given references to paragraph 67 at 2907, not going to them now, 67 at 2907 of the Court of Appeal judgment and 75, paragraph 75 at 2909. But to just make the point that they were not dealing with section 20 subsection 8, although we say that the clear view expressed by the Court of Appeal is absolutely germane to the subsection 8 issue, because they were saying that the local authority, basically in terms that the local authority could not properly comply with a request to remove the children because of the breach of the bail conditions. But the reason that the Court of Appeal was not specifically dealing with subsection 8 was because the case that there had been a request for removal under subsection 8 was not run by these appellants, Mr. and Mrs. Williams, either at trial or in the Court of Appeal. So it's appeared now before this court, but because it was not run, of course it was not then addressed in those terms by the Court of Appeal. But we do nevertheless say that those very clear statements by the Court of Appeal absolutely tie in with subsection 8. And we say that it is a correct statement of principle. We suggest as a starting point, we're going to some authority in a moment, we suggest it's fundamental that Hackney could not lawfully cooperate with a removal which would itself trigger immediate breach of the bail conditions. And we say that subsection 8, despite its explicit, very short, clear, mandatory, unqualified terms, that right of the parents in this particular situation, and obviously comparable situations, is vitiated by public policy. And we've given your ladyships and your lordships a short clip. There's a little index at the front, 4 items. The first 3 relate to this point. The last one is a very short, different matter altogether that we'll come to in due course. But the first is, after a well-known dismissed judicial review, and we've copied for the court paragraphs beginning under the heading, if the court has that, beginning page 285, that's just go by the internal numbering, under the heading Public Policy Considerations. And it says, a related question to that of administrative inconvenience is the extent to which public policy might be employed to rebut the presumption that a statutory provision is mandatory. Public policy is employed, oh dear, never mind. Public policy is employed here as the public law equivalent of private law equitable principles, such as that which states that no person may benefit from his own wrong. Thus, the courts will presume that Parliament did not intend to imperil the welfare of the state or its inhabitants. We just comment there.
Yes.
Sorry, I was just allowing.
We're trying to sort out the leak.
Oh, well, I will, my lady, then, if
Carry on. We're listening.
yes, well, I'm not sure how I can sort it out, my lady, but...
No, we're going to.
We're trying to sort it out.
You.
I beg your pardon.
You ignore the leak.
I'm so sorry.
Continue.
I didn't catch that, my lady. I'm grateful for that. Thank you very much indeed. Apologies for creating that problem. The welfare of the state or its inhabitants, that ties in with the bail conditions, my lady, because after all, bail conditions go to the welfare of the state or its inhabitants. That's what they're about. They're all part of the overall administration of justice. The police powers have that fundamental aim. This question arose, and we come to this case. This question arose in the case of the Queen against the, and Registrar General ex parte Smith. The appellant was detained in a secure mental hospital following his conviction for murder and the manslaughter of a cellmate during a psychotic bout under a belief that he was killing his adoptive mother.
This is tab 2 of your new bundle, isn't it?
It's tab 2. This is tab 1, Lord, my lady. The text book is tab 1, and the case is tab 2.
You've got the actual case, haven't you?
You've got the actual case is tab 2,
yeah.
And then there's another case, which is also mentioned in a footnote here, which is tab 3. So we're in tab 1 at the moment, and over the page at 286. The mother's identity, he had no knowledge of his natural mother's identity and applied under Section 51 of the Adoption Act 1976 to the Registrar General for a copy of his birth certificate. The application was refused on the ground that the Registrar General, after receiving medical advice, thank you very much, after receiving medical advice, believed that Smith's natural mother might be in danger if he were ever released and her identity known to him. Under the statute, the duty of the Registrar General to supply the information was in terms absolute. Nevertheless, the Court of Appeal held that this duty may be vitiated by public policy. In this case, the public policy involved the prevention of crime. Parliament is thus presumed not to have intended that a statutory duty should be enforced either to reward crime in the past or to promote serious crime in the future, nor should the duty be enforced if there is a significant risk or current and justified apprehension that to do so would facilitate crime resulting in danger to life. And in Smith, it was made clear that the decision of the Court of Appeal was in no way connected with the discretion of the court to refuse relief in judicial review cases. So that's an important qualification. Nor was the language of a directory as opposed to a mandatory statutory provision employed. In effect, the court held that a mandatory provision may simply be vitiated by the dictates of public policy, and rightly emphasised that such a result is founded upon the interpretation of statutory purpose rather than upon any strained distinction between mandatory and directory statutory provisions. Today, under the terms of the Human Rights Act 1998, conventional rights might have been specifically invoked in such a case, as public policy is an unruly horse which must be ridden with care, as public policy as policy is within the proper realm of the legislature and not the courts. And a footnote.
Could I just ask?
Yes, my lord.
This is a really fundamental point that you are raising. Are you raising it for the first time today in this court?
My lady, I'd have to say we'd raised it for the first time yesterday. I think
Well, yesterday evening.
Yes, indeed.
Yes.
Yes,
And you have given everybody else notice of what you're saying and good notice of these authorities. I mean, we're familiar with them.
No, I understand that, lady. Yes.
Some of us have been in one or two of the cases.
Of course.
But have you given proper notice? This is a really fundamental argument that you're raising for the first time yesterday. And you're now producing some important authorities for us. Have you given the other side proper notice?
We gave them immediate notice. It was yesterday evening, my lady. We gave them immediate notice, of course, as soon as we.
You obviously didn't to the interveners.
I beg your pardon?
You obviously didn't to the interveners.
I think did we ask the.
I'm not going to stop you raising it.
No, my lady. But we'd had some late night communications. I did ask, and they agreed to pass on something to the interveners, but perhaps it was the Bail Act stuff, which I. Yes, I apologise, my lady. Late last night, the clip has been prepared overnight. Sorry. And
this is not the way things are normally done in this.
No, my lady. We
You're asking us to take a very extreme position because this situation is very rare. It's only very rarely done.
It's certainly.
Anyway, carry on. I'm just raising the point and protesting somewhat. On behalf of the other parties and even more on behalf of this court.
Perhaps you could reduce your proposition to 2 or 3 sentences, then we'd see just how far it goes.
Yes, the proposition is this. It really reflects what we were saying yesterday. The proposition is that when the if you like the literal application of what an apparently mandatory provision leads to I'll describe it as an unlawful result, and there'll be degrees of unlawfulness, if you like, but when it leads to an unlawful result, it may be that
it has to be modified.
That in the particular context of that, and each statute and each provision has to be looked at in its own terms, that the intention, as is made clear in that passage from De Smith, the intention of Parliament may then be concluded to be that it did not intend the literal terms to involve an unqualified mandatory right or unqualified mandatory duty, that it was subject to a qualification that in the particular circumstances where that, put it in broad terms, unlawful result would or be likely to ensue, that it should be qualified so that the right would then not apply in those circumstances.
But that's a different proposition from the proposition that an apparently mandatory statutory provision is disapplied in an exceptional situation where public policy, there are such strongly countervailing public policy considerations that it shouldn't be applied. That is different. I don't think that anything that Mr. Smith was asking the registrar to do was unlawful.
No, what it's this, my lady.
It wouldn't necessarily have led to his behaving in an unlawful way.
No, he wasn't. Well, precisely, my lady. He wasn't asking. He wasn't, of course, asking the registrar to do something that was unlawful. The registrar was.
No, he wasn't doing anything unlawful.
Of course, well, if I'm taking stages, my lady, of course he wasn't asking the registrar to do anything unlawful, but he was, his getting the certificate was not itself unlawful. As your ladyship is well alive to it, what it was that it involved then, if he obtained the certificate, it would then identify his natural mother, who was then thought to be seriously in danger because he had, after all, perpetrated a psychotic killing, if I put it in shorthand.
That's
like
true.
that. And so that
Very dramatic case.
Yes, a very strong case in the sense that the danger that might have ensued, of course, was extreme. In a way, paradoxically, in a different direction, slightly less strong, because that danger wasn't immediate and wasn't inherent in the exercise of the right and the response of the authority concerned. Whereas in our case, we say that the breach of the bail condition is the inevitable immediate result of the purported exercise of the right under subsection 8 and the local authority's response to it if it were to comply with that.
Can I just be clear? I mean, I think this arises out of my request for you to identify where the Court of Appeal dealt with section 20 subsection 8. And we found it didn't in terms.
It didn't, correct.
But you say that is because no one ran that argument in the Court of Appeal.
Yes.
Which, if it's right, would explain it. And now you're coming back and saying, well, actually, inferentially, you can see that had it been raised, they'd have dealt with it in the way they did in paragraphs,
Precisely, my Lord. Yes.
paragraphs you mentioned, on what are effectively public policy grounds, although they don't spell that out. You're now giving us chapter and verse for what they might have said if they had actually been faced with that issue. I mean, that's how it sort of comes up.
Yes, my Lord. That's a perfectly fair way of...
But we are clear, are we, that it wasn't run as a point in the Court of Appeal?
My Lord, yes, that's Mr. Sinai was there in the Court of Appeal. We are clear, it was not.
Well, it's certainly been odd for the judge not to have dealt with it if it had been run.
Well, indeed, my Lord, yes, absolutely.
I'm just trying to see what effect this has on the terms of section 20, subsection 8. Just looking at those terms, do I understand your argument to amount to this, that the words, provided that to do so was not unlawful, should be added to the subsection?
Well, in a sense, my Lord, yes, that's certainly one way of dealing with it.
If there's another way of dealing with it, I'd like to hear it, because I haven't quite grasped the remnant of your argument yet.
My only reluctance, my Lord, in saying that it's dealt with by reading words into the statute is that it's clear that the matter has, although underlying principles, of course, but these have to be dealt with case by case, so that the court would look at the particular issues which arose, as in the Smith case that we're coming to, and also the footnoted case at 281 footnote into Smith of Welwyn Hatfield Borough Council.
Which you also supplied us with. Yes, but that was why I raised the question of the distinction between unlawfulness and public policy. Because, yes, public policy is an unruly horse.
Indeed.
And it is a very difficult concept often to put one's finger on. But certainly there are questions of degree.
Yes.
Unlawfulness is a rather different issue.
Yeah. Well, my lady, may I say, I was invited to summarise in a couple of sentences.
You've produced this argument. It's for you to explain to us what it is.
Certainly, I hope I'm doing that, my lady. We'll do it. Just a moment ago, what I was doing was responding to Lord Carr's invitation to try to encapsulate it in just a couple of sentences. But I would like to make the reservation in trying to encapsulate it for Lord Carr that it's a slightly crude encapsulation. I gave that label of unlawfulness, but it's not as simple as that, because as we seem to be in agreement about that, you have to look at the particular case to see whether, as a matter of public policy, the apparently unqualified mandatory terms of the statute in question should be vitiated by the public policy issue in relation to the particular danger or the particular risk or the particular consequences if it were treated as unqualified.
Is it any unlawfulness that you're talking? Is it any unlawfulness?
Well, no, you see, I don't. I don't wish to say yes to that, my lady, but also don't need to. In effect, it's not.
No, but the reason I was asking was, suppose that the parent says, "I want my child back, and I will beat them." Criminal offence. I will beat them when I get them back. There's a scheme for dealing with that under Part 4, but Parliament ignored that, and it's a public policy issue.
The difficulty of that, my lady, is only that what will be involved in particular circumstances is the seriousness of what might happen, and the degree of likelihood and concern that it might happen, as opposed to there's a spectrum from a speculative possibility that there's a risk to something which is immediately going to happen. In the Smith case, with the terrible history of the killing and the psychotic episode in the Smith case, although of course the danger wasn't speculative, it was by no means sure that it would happen, but the position factually appeared to be that if the certificate were not issued, then for practical purposes the risk would be eliminated, because the man wouldn't know who his natural mother was. If he were able to identify his natural mother, there was seen to be a sufficiently serious risk that the certificate ought not, despite the mandatory terms, and they're footnoted in De Smith. The Registrar General shall, on application made in a prescribed manner, so it was expressed in unqualified terms.
Or another example, to add to Lady Black's, what if a residence order in favour of a mother has a condition that she should live in Devon for contact purposes with the father? And the child is accommodated, and she wants the child back and says, I'm going to go and live in Northumberland. Does the local authority then say, well, I'm afraid you have no rights under Article 8 because you're breaching a condition of the residence order?
Well, I'd put it this way, my lord, there would be an argument. I don't feel, because they are dealt with case by case, I don't feel that we have to, on our side here, I don't feel that we have to commit ourselves to an answer on that, my lord, because what we are talking about, we're dealing with a particular case, what we're talking about here is something which is fundamental to the administration of justice. Now, it might be only police bail, if you like, as opposed to something imposed by the court. But I really don't attach much weight to that only because it is, after all, important part of the administration of justice that in circumstances as we had here, where the police are investigating a crime, not of course at the most serious end, but a potential crime not trivial either, that the price of liberty is the condition of bail, and well, it wouldn't be a difficult proposition to say that compliance with bail conditions is important in the overall administration of justice in the interests of society.
Well, of course it is. However, if I can add to the questions that have come from my left, does that apply to all 8 of these children? The reason why this condition was imposed by the police was the absolutely standard no interference with victims. How does that justify depriving an 8-month-old baby of contact with a breastfeeding mother? If one's looking at public policy and degrees of unlawfulness, you say it's a case-by-case, fact-specific thing. Well, I toss that in. The younger children, the expressed reason for imposing this bail condition really certainly didn't apply to the baby and probably didn't apply to the young children at all. It probably did apply to both the older boys and maybe the younger ones.
Well, milady, there are a number of observations. First of all, we on our side have we've always recognised ourselves that there is this practical distinction, but to practical points we made, this distinction has never been part of the case against us. First of all, so we have not been put in the position of exploring this distinction.
But you've never raised this argument until last thing yesterday.
Well, yes, but in any context.
So it's not reasonable to expect them to put it against you when the argument wasn't made.
Well, not in relation to this particular point, my lady, but plenty has been said about the bail conditions in the course of the case.
But I mean, it's part of the Court of Appeal's reasoning that the authority couldn't frustrate the bail conditions. And that was dealt with. And it seems to me they clearly took that view. And whether that's right or wrong, I think is quite a difficult question. But so, I mean, in a sense, I think it's slightly unfair with respect to accuse you of taking the point for the first time. But certainly it would have been nice to have a bit more notice of the way you're putting it. But I do see, I mean, the point my lady puts to you is actually a very significant point to take into account if one's looking at this as a general issue, because one's clearly got to deal with it on a case-by-case basis.
Well, thank you for that, Lord. I don't want to take up the court's time in a irrelevant defence of the way that we dealt with the matter. That would be pointless.
Mr. Can I just, I mean, I've been looking at the skeletons in the Court of Appeal. I mean, the point does seem to have been flagged up, but the issue seems to have been whether withdrawal meant simply physical withdrawal, turning up and saying, I want my children now, which clearly didn't happen in this case, or whether it's enough to indicate we want them back, which clearly was done in this case. And there is quite an important point of principle there.
Yes. Well, Lord, we certainly are coming on to the question of whether there was actually, I say in fact, but obviously in fact and in law, if you like, whether there was actually a removal or a request to remove under subsection 8. We deal with that separately. But I haven't lost sight of your ladyship's question. The answer we give to the essence of your ladyship's question is that we're talking about two different levels here. What was behind the bail conditions and whether there was actually a justification for the bail condition based on the reason of non-interference with witnesses in relation to the tiny children. That's, if you like, that was, in the first place, that was a matter for the police. Now, it may be said that they did not need, that their reason given, they only have a restricted number of possible conditions they can impose. But milady, we can't argue with the fact that, as a matter of common sense, that particular reason for the condition can't have had any actual application. Of course we accept that, but we didn't impose the bail conditions, the police did. And then if we just pursue this question of it being on two different levels, those were the bail conditions. So rightly or wrongly, and whether there is a sensible basis for every ingredient or for the bail condition of all 8 children, the principle that the compliance with bail conditions is fundamentally important remains. So perhaps labelling that next level as irrelevant is putting it a bit strong, my lady, but you see what we're saying, that
Yes.
we don't have to go.
I do, but I was raising it because of the public policy considerations. And it seems to me the public policy in preventing interference with witnesses is important, but the public policy of not separating a baby from a mother is even more important. Many would think.
It certainly is, my lady, and those are balancing considerations. But we would say that bail conditions in this particular case, which of course it did sensibly relate to at least some of the children, but we would say that compliance with bail conditions is very fundamental. And of course, where we came from really in relation to this, based on the Court of Appeal's findings, is that that does appear very clearly to have been the Court of Appeal's view, that it was really just, they weren't specifically looking at Section 8 in this context, of course, but there are a couple of statements in this are very clear, and all 3 members of the Court of Appeal seem to have taken the view that this really was, I'd summarise it this way, that the local authority could not properly deliver up these children, I'll put it that way, that's a non-statutory phrase, but they couldn't properly return these children to the parents in contravention of the bail conditions, or inevitable contravention. Obviously, it's not the local authority that's in contravention, but couldn't aid and abet and immediately allow the flouting of the bail condition. That's exactly the way they put it. So we've presented it to your ladyships and your lordships on that, if you like, simple, but we say correct basis of principle. But we are now, with recognising all the comments that your ladyships made this morning, we're now supporting with some authority. So that's where
Indeed.
That's where we are.
Basically, it comes down to it stands to reason, and now we're going to find what the reasons are.
Indeed, yes. Yeah. And just a comment, my lady. After all, this whole question of variation of bail conditions, after all, it was always open, so far as the bail conditions might have been thought to have not rationally applied to some of the children. It was therefore always open to the parents, advised by very experienced solicitors to make that application and raise that point. But they never did. So, but
does public policy require the local authority to participate in the process of altering the bail conditions where they've taken a decision that the children should be going home but for the bail conditions?
On a technical level, my lady, we had no locus, to use old-fashioned word, we had no standing to...
There's no problem about writing a letter.
No problem about writing a letter. Your ladyship clearly has in mind that there was a request. May we come to that? That really
all right. Don't take it out of turn.
It arises here, but it belongs in another box anyway, so thank you for that.
Well, we'd better stop interrupting you because you've not got a lot longer and you've got 2 rather important boxes to open.
Thank you, my lady. We hadn't lost sight of that. Can we go then to the Smith case? I will take it as quickly as is reasonable to do. That's item 2 in your lordship's clip. We can go straight to page 39F. Yes, we can go straight to 39F. Just to remind ourselves, 398F. Did I say that? just to remind ourselves of the provision. The statutory provision is cited there at F and G. I'm sorry, that was the response. I showed your lordships the statute, and then the response was, she will not provide the applicant with the information necessary to enable him to obtain a certified copy of the record of his birth. The decision is based on public policy grounds in the light of the medical and social reports available. And then if we go to 399D, we get that's the statutory provision, and it's subject to where at D, where it says subject to subsections 4 and 6. Those didn't arise. That doesn't affect the matter. So the citation then in De Smith's book is the rest of that section, and then we get a citation at page 400 from a judgment of Lord Justice Watkins in an earlier case, and I'm sorry, in the divisional court, I beg your pardon, in this case, and just the last 3-4 lines. It is, we think, beyond belief that Parliament contemplated that an adopted child's right to obtain a birth certificate should be absolute, come what may. So, if you like, that's the basic approach. It's reinforcing, or it's making it clear it's Parliament's intention that they are looking at. And then, if we go to 401. EF, and that's where Mr. Laws, who was a amicus curiae, or with Mr. Pleming, a Mikey curiae, I accept Mr. Laws's submissions. It's clear that the facts giving rise to this application of this appeal are wholly exceptional. I do not believe that Parliament intended to provide an absolute right to the relevant information, come what may. And then 402F, Lord Justice Staunton, he cites a proposition at E from Lord Justice Donaldson in a case of Puttick, and then says, in the case of statutory duties, the rule, in my opinion, based upon the interpretation of the meaning intended by Parliament, it's not a rule imposed ab extra, as in the case of contracts, which he's dealt with. And it's only fair to indicate how he puts it in this case. So at G, he says, so the rule is that we must interpret acts of Parliament as not requiring performance of duties, even when they are in terms absolute, if to do so would enable someone to benefit from his own serious crime. Now, of course, he's talking about that case there, and that's enough for the purposes of deciding this case. He's not saying, and we don't believe he would have been, or we don't submit that he would have been intending such a qualification. He's not saying, but it's only ever in cases of serious crime that this principle can be applied. He, at the foot of the page, he refers to Benyon, and then says, Mr. Gordon, who appeared for the applicant, was prepared to concede it would be a natural extension of existing public policy if the courts declined to enforce statutory duties when a person required performance for the purpose of a crime which he intended to commit. A rule so formulated would not apply in this case, for it cannot be said on the facts that the applicant was shown to intend any crime. That's the point on which our case here is paradoxically stronger, if you like, because it's more direct. I've made that point. The breach of bail condition, it was a more direct consequence of of the unqualified approach to the right and the duty. Then we go to G, where it says a more practical distinction between or F rather, more practical distinction between declining to enforce a statute when to do so would enable the person to benefit from serious crime in the past, and declining to enforce a statute because it's apprehended that to do so would facilitate serious crime in the future. And similarly, it's the same point. It would be immediate in this case, and he's persuaded about the principle. And then he says at B, still Lord Justice Staunton, on the opposite page, 404, nor would I limit the principle, as Mr. Gordon does, to cases where performance of the statutory duty is required for the purpose of a serious crime which the applicant intends to commit. It must be a matter of degree. The likelihood of future crime and the seriousness of the consequences if crime is committed must both be taken into account. For present purposes, it's sufficient to hold that a statutory duty is not to be enforced if there is a significant risk that to do so would facilitate crime resulting in danger to life. Parliament is presumed not to have intended that unless it said so in plain terms. That's as far as I'd go in this case. Even so, I fear that other cases may require further elucidation, as, for example, this one, the latest. And then in the judgment of Lord Justice McCowan at page 405, B, in my judgment, the correct formulation of the public policy in this context is that the adopted person will not be permitted to exercise his right under Section 51 of the Adoption Act 1976 if there is a current and justified apprehension of a significant risk that he might in the future use the information obtained to commit a serious crime. So that's all we wish to show your ladyship and your lordships on that case. And then tab 3, which is the Supreme Court decision in Welwyn Hatfield Borough Council. 7 justices of the Supreme Court on that case, including, of course, your ladyship. This was way down the scale as far as the crime was concerned. So we have gone down the scale.
Quite an amusing case. Yes.
Yes, we have gone down the scale. There are lots of angles of this case which are nothing to do with the point today, as your ladyship would know. But it was all to do with about 10 lines down in the head notes, section 171B2, we're talking about Town and Country Planning Act, which provided, so it's familiar territory for at least some members of this court, certainly, but which provided for a 4-year limit, time limit for enforcement action against a breach of planning control consisting in the change of use of any building to use as a single dwelling house. And then about 5 lines down, however, the inspector found as facts that inter alia the builder had said that he deliberately deceived the planning authority when he'd applied for planning permission for a barn, that he'd always intended that the building should be a dwelling house, that the building had never been intended or designed for any other use than a dwelling house, and that the builder admitted that he'd carried out a planned and deliberate deceit over an extended period to establish immunity from enforcement action. And, my lady, we can go all the way to page 325, because there were lots of other issues in the case which don't arise here. And in the middle of that page, under the heading, the second issue, merits. And then we can start at page 45. And so what we had was, we had this clear deception, admitted deception, and the literal application of the provisions of the Act would mean that he would have got away with it because the 4-year time limit had expired, presumably before it all came to light, and he'd have got away with it as opposed to a 10-year limit. And he didn't get away with it. That was the result of the case. But at 45, the Council relies upon a principle stated in Halsbury's Laws of England. Law should serve the public interest. It's the basic principle of legal policy that law should serve the public interest. Where a literal construction would seriously damage the public interest, and no deserving person would be prejudiced by a strained construction to avoid this, the court will apply such a construction. In pursuance of the principle that law should serve the public interest, the courts have evolved the important technique known as construction in bonam partem, in good faith. If a statutory benefit is given only if a specified condition is satisfied, it's presumed that Parliament intended the benefit to operate only where the required act is performed in a lawful manner. And then illegality, I don't really need to read the next, I think. And then it goes on to Benyon. I just mentioned the paragraph. Please perhaps not spend time reading it. And then if we go to page 328, what we have here, by the way, is the judgment of Lord Mance, with which several other members of the court, including Baroness Hale, were in agreement. It was a clear majority. The 51, the decision in Puttick, and Puttick was quite an extreme case. Puttick was a member of the Baader-Meinhof gang in Germany, so clearly we were talking again pretty high up the range of the scale of criminal activities or potential criminal activities. But at 51C, in the present case, if, as I'm assuming for the purposes of considering the second issue, Mr. Beasley satisfied the literal language of the relevant statutory provision, so that's assumed, of the sections, he only does so because he has successfully deceived the council into giving him planning permission to build a hay barn, into thinking that he intended to build and was building such a barn, and into thinking for more than 4 years, the limitation period, that he had done so. And then 52, the other respect in which the present case differs from Puttick. There's a pretty big difference between planning and Baader-Meinhof. We can see that straight away. The other respect in which the present case differs from Puttick is that Mr. Beasley's conduct in obtaining the planning permissions by deception, perhaps surprisingly, did not involve any identifiable and provable criminal offence under the law as it then stood. It could now be under Section 2 of the Fraud Act 2006. So that's important as well. So we were apparently not surprised to everybody, perhaps, but it apparently wasn't a crime. And then 53, since the ultimate question is whether it can have been the intention of the legislature that a person conducting himself like Mr. Beasley can invoke the benefits of sections 171B and 191. I do not consider there can be any absolute principle that public policy can only bear on the legislator's intention in a context where there's been the commission of a crime. The principle in the passages cited from Horsby and Benyon is one of public policy. The principle is capable of extending more widely, subject to the caution that is always necessary in dealing with public policy. Some confirmation in the case of the need for an actual crime, not absolute, can also be found refer to the Smith case. And then 54, whether conduct will on public policy grounds disentitle a person from relying upon an apparently unqualified statutory provision must be considered in context and with regard to any nexus existing between the conduct and the statutory provision. And then at 56, here Mr. Beasley's conduct, though not identifiably criminal, consisted of positive deception in matters integral to the planning process, applying for and obtaining planning permission, and was directly intended to and did undermine the regular operation of that process. Now, my ladies and my lords, what we say here is that, and it's important to consider this case alongside the Smith case involving a potentially very serious crime, because actually, if you like, between well, we won't necessarily say between that very serious crime, but we put it this way, that above the regular operation of the planning process must come the administration of justice and compliance with bail conditions. If one is reckoning some sort of scale of seriousness to be put on one side of the balance on public policy, we would say that compliance with bail conditions is above regular operation of the planning process. So this is an indication that when you're looking at the circumstances of a particular case, you don't have to go into that area of very serious crimes. So what we do have here is what is in effect a serious, it may be just a very specific thing, and it may be, if you like, just police bail, and it may be just a condition, but this would be a direct infringement and undermining of the system of administration of justice and the application of the criminal law, because it was all connected to the investigation by the police of a potential, because in the end there wasn't a trial, and they are, of course, in criminal terms, innocent. Mr. Williams innocent of this crime. We do stress that. But at that stage, we were looking at that in that context. And we say that the principle here, and let's just put it in, if one likes, the most simple practical terms. And this is, in a way, going back in the most basic fundamental terms to what was clearly the Court of Appeal's view. Parents turn up, not literally in this case, but figuratively, we could say that. Parents turn up asking for their children to be handed back to them, and the local authority says, well, you'll be in breach of bail condition if we do that. I mean, this is what it comes down to in the end. And then the parents say, well, never mind about that. Have a look at subsection 8. It's unqualified. And what we're saying is Parliament can't have intended it to be unqualified. They can't have intended in those circumstances to put a local authority, a public authority, in the position where, in order to implement the statutory right under subsection 8, it had to immediately facilitate a flouting of the bail conditions. And that was what the Court of Appeal was saying. And that's it in simple terms. And we say it's obviously right. it cannot have been right for the local authority to hand back children immediately, triggering a breach of the bail conditions. And the reason, the corollary of that cannot be right, is it cannot be right that the parents had the unqualified right under subsection 8 to ask them to do that, because they go together. Because if the right under subsection 8 is unqualified, then that answer from the local authority is necessarily not a valid answer, because the parents then say, you get a standoff, but the local authority say, well, we can't do something that leads immediately to breach the bail conditions. And then the parents say, but we've got an unqualified right under section 8. Let's suppose notionally they've got a solicitor standing alongside them saying it. We've got an unqualified right under section 8, subsection 8, and then the local authority's solicitor says, well, I'm afraid that subsection 8 right is not vitiated by public policy in any way. You've got to hand them back. And that's exactly the result which all three members of the Court of Appeal clearly thought was simply not a possible result. The local authority would have to say, no, we can't.
Well, no, the Court of Appeal was looking at subsection. I'm so sorry.
Sorry, my lord, my fault. I was just trying to take something in my left ear.
Of course. The Court of Appeal was looking at subsection 7. Subsection 7 requires inquiry into whether the person is able to provide accommodation. It was in that context that the Court of Appeal said the bail condition precluded the parents from being able to provide accommodation. But we have, luckily, now moved into subsection 8, as to which the Court of Appeal said nothing. So we've got to say something.
Yes, my lord, but what the Court of Appeal did say in the paragraphs 67 and 75 is plainly in terms applicable to this situation under subsection 8. Yes, well, I know I'm repeating myself, my lord, but that is the answer.
It, and I think you said there was another string to your bow under subsection 8, and it might be time for you to move to that.
As a matter of fact, my lord, that is precisely
well.
where I'm going at this very moment. Yes, so we're on the same page. Yes, the other string is the submission that neither appellant ever did remove or attempt to remove the children under subsection 8, it's in the summary point 5 in our written case at 2816, and that it just says that's just in our list at the end in compliance with the rules. We should say first of all, we don't want to stress this too much, but we do mention that this is consistent, and we make this point at paragraph 57 of our written case that Mr. Williams agreed in cross-examination that he and Mrs. Williams had never sought to remove their children. But I don't want to push that too far, my
we
lord.
Haven't got the transcript.
Because,
have we?
No, my lord.
We haven't got the deputy judge recording that, have we?
No, we don't have it in the judgment, my lord. That's what Mr. Sinai, who was at the trial, says it. But I don't want to push it too far because after all...
that might be important, but one would be nervous about using that, being unable to look at the context,
my lord,
the question and the precise answer.
My lord, let me not press it, because I'm going to say in any case, it's if you like, there's an element of law in it as well. So what Mr. Williams said under cross-examination, I won't press that at all, then, my lord. What we do get is that if we look at the correspondence, we know that, and we'll come to just briefly some of the various letters, that, let's start with the 9th of July. And first of all, what has been labelled as the pleading point, we would like to clear this up a little bit. In their written case, the appellants rely on, and this is at page 2774, and I think we do have to look at this. Excuse me one moment. Have I got the Yes, at paragraph 92 at page 2774, it's the second sentence. They say the Court of Appeal, were the parents prevented from exercising the right to remove, the Court of Appeal did not expressly address the failure of the local authority to return the children to the parents' care once they made it clear they wished to remove them. We said that's right. At first instance, the local authority, there's the language got a bit tangled here. We think this should read, at first instance, the local authority admitted that its stance in the face of the parents, we think the words they and had should be scrubbed out. I doubt there's any argument about it. So, at first instance, the local authority admitted that its stance in the face of the parents stating that they would remove their children from local authority was to inform them that they could not do so, thereby preventing the operation of Section 28. Can we just look at just the way it's put? It's in Appendix 2, and we just need briefly Appendix 2. Have you? Okay. Maybe go to Labour laws. Maybe work just here for the moment from the internal numbering, but Mr. Sinai will give us the MS numbering in just one moment. It's 443 in Appendix 2. And over the page at 444, 443 is particulars of claim. And what's said is that it's 3320, the memory stick number, 3320. After 72 hours, the couple returned to the local authority, but were told that they were not permitted to take their children home, as their treatment of the children was under investigation. And
sorry, what are you referring to?
It's at page 3321. It's paragraph, the numbering, it's paragraph 5, but it's paragraph 4-5, but the numbering is in the same style. So it's a page, it's at the MS page 3321, and it's actually a sub-paragraph 5 in the middle of that page. Does your ladyship see that? Yes. Yes, after 72 hours, the couple returned to the local authority, but were told that they were not permitted to take their children home, as their treatment of their children was under investigation. We admit that. We say the claimant's children were lawfully accommodated, of course, is our position, but we do admit that they were told that. And that's as far as it goes. They were correctly told in our submission that they were not permitted to take the children home. And they weren't. But we go back a little bit to the previous point, factually. They weren't permitted to take the children home. We were telling them entirely correctly what the position was, because the bail condition prevented them from doing that. And then Ms. Fottrell relies, and her side of the case rely on Sternberg-Reed's 13th of July letters. And we go to 2973. We're back in the core bundle. Your Lordship's seen, your Lordship has seen some of this material before, of course, but 2973, the Sternberg-Reed 13th of July letters, which we looked at. Lady Black asked, in the course of argument here, Lady Black asked where were the judge's findings on these letters, and they're not, so far as anything could remotely approach findings. We see that at 2951, and it's paragraph 84. I reject the defendant's attempt to justify their omission to make a court application on receipt of the Sternberg-Reed letters of 13th July. Absence of a contention that any consent originally offered was invalid does not amount to a retrospective ratification. The acknowledgement that the defendants would need time to complete their investigation, no more than an acceptance that if the authority was determined to keep the children, there was nothing the claimants could do about it practically in the short term. That does not amount to a consent, but to a submission in the face of the power of authority. In my judgment, the letters amount to an express withdrawal of any consent that may have been signified at the time of the signing of the agreement. For these the reasons stated above, acquiescence and not amount to an agreement. So the judge wasn't addressing them. He wasn't being asked, consistently with what we told the court this morning, he wasn't being asked to view them as a request for removal, because that wasn't the way the case was being run. He was saying it was withdrawal of consent. But even if that is treated now, or were to be treated as a request for removal under subsection 8, the removal wasn't required, and that's in terms of the letter. The removal wasn't required until the 23rd of July. And on the 23rd of July, at 2983, Sternberg's right, and among other 2983, Sternberg's right to the local authority. And you've also seen this letter before, and I don't want to go through every paragraph, but they make the point in the fourth paragraph that you currently have no legal basis upon which to keep these children in the care of the local authority, which of course we dispute. But then the last paragraph on that page, our client instruct us that notwithstanding the above, he is not going to act precipitously, as he would not wish to place his children in the middle of a potentially distressing situation. And then they await an urgent response, and the urgent response comes at 2985 the following day. That letter's the 23rd, and on the 24th, the local authority respond, and among other things, at the bottom of the page, 2985, we therefore trust that your clients will not seek to remove the children from the care of the local authority until clarification can be obtained with regards to the police bail condition. Therefore, be grateful if you could confirm the following, and so on. And then, penultimate paragraph on the opposite page, this matter has been presented to the Children's Resource Panel of the London Borough of Hackney, where a full discussion has taken place as to the plan for reunification and provision of intensive support and monitoring package to your clients and the children. Obviously, your clients' cooperation will be required. And just to remember that by this time, quite a little bit before this time, by this time, with extremely good cooperation between Mr. and Mrs. Williams and Hackney, the physical issues in relation to the accommodation had, well, at least very largely and happily been resolved. But the Sternberg letter then, so they've asked that, and then at 2987, Sternberg's right in response, thank you for your letter of the 24th, so we're now on the 27th, and Sternberg's right in terms which have dropped the insistence on removal, and their focus has switched to negotiation. And at 2909, and this is in the Court of Appeals judgment, the presence of Brian Levison's judgment, we've looked at this at 75. We referred to it in the other context. The first sentence is the one that bears on the subsection 8 submissions I've just been making. And then the second sentence, third line, the only inference to be drawn from the fact that the condition remained in place was that the parents, no doubt on advice, were prepared to negotiate with the police rather than risk a conflict in court. So what had happened was that the letter at 2985, the 24th of July letter from the local authority, also had invited, I don't want to go back to the letter right now, but had invited Mr. and Mrs. Williams through Sternberg's to a child protection case conference on the 31st of July. And the minutes of that conference are in Appendix 2 at page 3083. And again,
internal page number, please.
206, my lord, is the internal page number. They begin, and you see the list of attendees at that page, 206, and it includes, of course, Mr. and Mrs. Williams, and of course a lot of representatives of Hackney, and representatives of the police as well, DC Laura McMillan, DC Jill Dark. And then the point, again, I don't want to go all through these minutes, they aren't there, but at 211, internal 211, which is 3088, at the very foot, just draw attention to that paragraph, DC Gill said that she feels all the children should be placed on the register under the category of neglect and physical abuse. DC Gill said that she knows it's the intention of Hackney to return the children to the family, but she stated there are concerns about letting the children return home when the parents don't accept that the house is unfit for children. We can't really help much. There seems to be some sort of, if you like, blurring of lines as between what's for the police and what's for Hackney, but this was, after all, a discussion at a conference, so it's not particularly surprising that some of that might happen. But it was really very clear that Hackney, as they always were, my lord, as we always were, Hackney was doing its best to get things moving, so these children, in principle, they were not interested in the children's interests or anybody's interest, not interested in any extended retention of these children in their accommodation. But they respond, and I'd just give your ladyships and lordships the note at 2989. They make it clear any application for bail to conditions to be removed must be made by your clients, which was true. And after all, Mr. Williams had Sternberg read from some weeks previously. And then what happens...
Just for a moment, I'm sorry to interrupt.
No, of course.
There's a reference at the top of page 3089. This is after both of the police officers have spoken in favour of registration. Ms. McLaughlin asked if the hearing yesterday would impact on any decisions made today. What hearing was that?
What was it? Excuse me, man. Well, Mr. Sinai, who's been through this matter throughout, isn't aware that there was such a hearing, so that creates a difficulty for us to yeah. We'll check that, of course, my lady. We do have Hackney with us, and we will check that. But we don't know, I'm afraid, is the simple answer to that.
It's some hearing referable to the criminal proceedings.
That's right. It's clearly something to do with the criminal.
Yes,
the policeman explained it.
Yes.
I'm sorry, my lord. Is it?
DC Dark replied that the outcome of the hearing was that the parents are going to bail on 17th August with the same condition.
Yes. So far as we believe, my lady, we can't say more than that. We believe that it was a hearing in the sense that it was at the police station.
It could have been an application to the police to vary the conditions, or it could have been, that having happened, an application to the magistrates to vary the conditions. It could have been either of those. But
my lady, completely confident, and I believe it's common ground. There's no suggestion that there never was an application to the magistrates for variation. Right. Mr. Sinai's got it. Yes. There was what's called a bail appointment the day before. It was at the police station. So, and that's at 2967. Thank you.
Thank you.
Well done. Thank you. So that was at 2967, and then these bail appointments, as it were, are happening from time to time. And at page internal 257 and MS 3130, we see, for example, that. Sorry. 3134, is it? Yes, 3134. Sorry, did I say it? 3134. I beg your pardon. Internal number 257, 3134. With reference to the bail granted on the 6th of July to appear at Stoke Newington, etc., at 9:30 on the 17th. To appear on the 17th of August at 9:30. We're unable to proceed at this time. This notice is changing the time and date at which bail must be answered to the 5th of October. So the police, apparently, they'd adjourn that hearing. Of course, by the 5th of October, the children had been returned. The bail conditions had gone, so that didn't happen. If we go to 2953 of the core bundle, it's paragraph 91 of the trial judgment. What we say, my lady, is that there seems to be, if you like, there's a suggestion coming through from the other side that in some way, and it may be in the minds of the court, in some way that the bail conditions were, or the removal of the bail conditions was in Hackney's gift, as it were, or that Hackney could simply trigger that. And the fact that there's an unwarranted inference to be drawn from the fact that discussion between Hackney and the police in late September, was it late September, beginning of October, late August, I beg your pardon, late August, at the very end of August, was then shortly followed by the removal of the bail conditions and then the children being returned home. But there was the inference that just because there was that communication between Hackney and the police, that it was just Hackney ringing up and saying, yes, it's time to remove the bail conditions, and the police saying, yes, right, we'll remove the bail conditions. That simply can't be got from the materials before the judge and indeed before this court. And at 91, the judge says it's likely that the police are willing to receive information from the defendants to help them form a judgment with regard to relaxing the bail conditions, that the defendants did not take this step before the 6th, that's us, before 6th September, is certainly not due to a lack of a request on behalf of the claimants. In my judgment, it's probable that the apparent reluctance to do so was caused by a collective concern that there were still issues to be considered in order to be satisfied that the potential risks for the children had been addressed. And that links with that paragraph that I said might have blurred, no doubt in a completely understandable way. There was a discussion at the case conference and so on with Hackney and the police and so on, and everybody would have been chipping in their views on, no doubt, all aspects of the matter. And then it says, the trial judge says, unfortunately, the coherent communication of what those concerns were was hindered by a failure to ensure that sufficient detail was conveyed with the overall description of the concern. The result was the police did not, until the 8th of September, receive a clear and accurate account of the progress of the defendants' investigations, as the police had their own independent concerns, which in the end led to multiple charges of neglect and assault. It's not possible to say what effect an earlier positive report from the defendants would have had on bail. It's clear, however, the claimants at least lost the opportunity to support an argument in favour of the relaxation of the condition at an early stage. So we just say it's just not as clear-cut as that. And perhaps a last point to be made here is that if at any time the parents had applied to the magistrates' court, which they could have done, for variation or removal of the bail conditions, and they did, after all, have solicitors who've hardly been unaware of that legal opportunity, then representatives of Hackney Social Services would have gone to court and, of course, would have then explained to the court what their current position and what the current state of knowledge and appraisal of the situation was. So that they were not asked to do that because no such application was made. So, my lords, my ladies, my lords, those are, I'm very close to my time, those are our submissions on subsection 8. I really, a lot of what we could say about the European Convention of Human Rights and so on, it's not unimportant, but first of all, we're going to hear from two interveners, and they are going to address that, and so we will have a short opportunity to deal with that in some ways.
No.
No, what?
No.
My lady, what?
It's not my understanding that either of the interveners from whom we're going to hear oral submissions is going to focus on the European Convention.
Well, I thought one of them might, Lord, but
well, the Equals Opportunities Commission does, but they're not giving oral.
No, I appreciate that. Well, I'd be surprised if they didn't touch on it at all, but all right. It's I thought they might, but I suppose they might not. What we'd say then, very briefly, in relation to particularly the Equality and Human Rights Commission, who of course aren't going to address the court, is that we've no serious quarrel with the statements of principle that they set out, and those are clearly gleaned accurately from the cases in question. But we've established, submit that Hackney's actions were in accordance with the law as we have analysed it. So we get over that hurdle, as the Court of Appeal regarded that as being. And we say it is really very straightforward. These it does follow the fact that the Court of Appeal then didn't analyse it in the structured way in which the cases indicate the questions should be approached. It doesn't mean that they haven't considered the issues. It's quite clear that the Court of Appeal did come to the conclusion, we say entirely correctly, that in the circumstances of this case, and starting from the position that Section 20 itself contains, and this relates to two cited authorities from the Equality and Human Rights Commission, Martich and Thames Water, and Agyarko and the Secretary of State for Home Department, that Parliament has set a policy under Section 20 which provides, after all, accommodation for children in need. We shouldn't lose sight of this. Provides accommodation for children in need in circumstances where, by definition, there is otherwise no accommodation available to them. It's quite important to remember that is what we are dealing with.
But I mean, you've got a finding by the judge that he would have found it proportionate.
Absolutely.
The Court of Appeal would only be entitled to interfere if the judge had gone wrong in principle.
Well, that's right, my lord. That finding is at paragraph 66 of the trial judgment. Yeah. That's clear. And what your lord says is obviously clearly right, but it's also clear that it wasn't just that the Court of Appeal would have been very constrained, of course, in interfering with the judge's finding. It's clear that they took the same view. One can get that very clearly from the Court of Appeal's judgment. The statute itself strikes an obviously correct balance between the competing rights of the children to whom the Section 20 subsection 1 duty is owed, after all. And of course, they've got their convention rights, including, of course, as part of the balance, a right appropriately not to be separated from their parents. We recognise that the children's rights go in different directions there, and you've got the parents' rights. And in the particular circumstances of this case, the bail conditions come into it as well. The Hackney was faced with the bail conditions as well. The bail conditions are there also to protect the rights and freedoms of others, including, if you like, the general rights of society to have bail conditions observed. Everybody has that right and expectation. And in the circumstances, we say the fact that the Court of Appeal dealt with it quite briefly is because, as the trial judge had found it was proportionate, to the Court of Appeal, we say correctly, and well, we submit in any case, the proportionality was obvious, that the children couldn't be lawfully accommodated by the children, and no alternative accommodation was available, and the children could not be left homeless. And that is where we were. There was, in a sense, there was no way out here. They had to accommodate the children. The duty was there. And so far as the questions of consent, we dealt with the question of consent because we say it's simply not required under this statute. And so far as it's relevant, I think Lord Carr made an observation yesterday that some of the cases where local authorities are criticised because the terms in which they explain the position to the parents at the initial step are regarded as in some way threatening. I think it was Lord Carr who pointed out quite rightly that, well, after all, on the one hand, if you start mentioning the possibility of court proceedings, there's the danger that somebody says, well, that's a rather threatening view to take. You mention court proceedings and that has an impact on the parents. But I think Lord Carr suggests, well, if you don't mention the court proceedings or the possibility of court proceedings, well, you're keeping something back. So you've always got a pretty difficult balance in explaining the position.
Could I just come back to something that was said earlier? The trial judge found, obviously, that the initial removal of the children was obviously both in accordance with the law and proportionate.
Yeah.
But by the time we get to paragraph 111, of course, which is where he's making his findings on the Article 8 claim, he says, of course, that he has found that the retention of the children over the next couple of months was not in accordance with the law. Does he make any finding about whether, if it had been in accordance with the law, it would have been proportionate?
No. No.
No, so there is no finding that the period with which we are concerned, that is after the expiry of the police protection and possibly for a while after that until it was clear the parents wanted the children back. Suppose that to be the facts. Obviously, we've got we've got arguments about the facts, which we'll have to look into. But there is no finding from the trial judge that it was proportionate.
No, in relation to that, that's correct, my lady. Yes, that's right. But
where is the finding from the Court of Appeal?
The finding from the Court of Appeal is what do we have an actual reference to there? They don't make a it's not that they make a specific finding, but they simply say that there was not a breach of the there wasn't a denial of convention rights. They just say it followed.
They reverse the trial judge's conclusion, he having said that it was not in accordance with the law, so there was a violation of Article 8. They say it was in accordance with the law, and they proceed to say, therefore, there was no violation of Article 8.
Yes, it's paragraph 70.
Is that right?
Yes, paragraph 76, my lord, which is at page 2909. They said in the circumstances, and one can go to the second part of that paragraph, in the circumstances, I would reverse that's trial judge's finding that the retention of the children after the period of 72 hours is unlawful, and equally that such retention constitutes a breach of the parents' Article 8 rights. On the basis of the lawfully imposed bail conditions, the interference was in accordance with the law, which it clearly was, and necessary for the protection of the health or the rights and freedoms of others. And we're back to a related point, really, that again, faced with, and it's not, after all, the local authority which imposed the bail conditions, faced with this situation, it clearly was necessary and proportionate. It clearly was. It did. The reason it's dealt with, sorry, I didn't continue reading the whole of the finishing off the paragraph, but the interference in accordance with the law necessary for the protection of health and freedom of others, it follows there was no breach of Section 6 of the 1998 Act, and damages should not have been awarded under Article 8. So it's stated in those concise terms, but it's clear, and it's clear, we say quite properly, because it is straightforward in this case. There really isn't any serious room in the circumstances, as they say, faced with those bail conditions, and in these circumstances, there isn't room, as far as Hackney is concerned, for a gap between the lawfulness of providing the accommodation under Section 20.
Did the parents argue in the Court of Appeal that even if the trial judge had been wrong to say that Hackney's actions had not been in accordance with law, nevertheless, there was, for other reasons, no justification of the interference pursuant to Article 8.2?
No, my lord. At your 15 minutes on. Lords, the last point, as far as damage is concerned, we are simply going to rely. We've set it out in our written case, and well, we don't have time anyway, so those are our submissions there. One final point is it's in relation to the comments, but I'm not going to go through those again. The comment made by Lady Black in the Red Car and Cleveland case, and that's those are noted in the appellant's case. They're in the authority, of course, but they're noted particularly in the appellant's case at paragraph 69, 2767. That was the comment that Lady Black had made in the Court of Appeal when she was gracious enough to remind everybody that her comment hadn't excited much argument. That she made the point, hadn't decided. We just want to say that it follows from the submissions we made yesterday that wasn't a case where there was a dispute that the parents had the right to object. The common understanding mentioned by Lady Black at the time, it follows from our submissions, is wrong. We'd just like to note item 4 in that clip. I said it was a separate matter. Item 4 in the clip, including the DeSmith passage and those other 2 cases, the very last item, which we have supplied to the other parties, is from the Children Act, Schedule 2, Part 1, and it's paragraph 7. Every local authority shall, provision to reduce need for care proceedings, every local authority shall take reasonable steps designed, A, to reduce the need to bring, 1, proceedings for care or supervision orders with respect to children within their area. And, my ladies, my lords, that's entirely consistent with everything we have said about the operation of Section 20. And I think we accepted yesterday that, of course, yes, the Hackney could have gone to court, but they didn't have to. And it was a perfectly fair decision not to, and it was perfectly lawful to proceed in the way that they did. And that's consistent with this injunction in the statute itself, not to go rushing off to court unnecessarily. So, my ladies, I did indicate that I was going to carve out a little bit of time for
yes, indeed.
learned junior.
Yes.
So those are
as he's been in the case throughout, it's only fair to allow him to get to his feet in this court.
I wouldn't wish to be accused of unfairness, my ladies. So those are our submissions so far as they come through me. So.
Thank you, Mr. Stewart.
My ladies, my lords, good morning still. I wish to address you very quickly on the issue of limitation. And given that there's only about 10 minutes left, can I propose this, that I simply give you the references to the documents, but I don't go to them, unless, of course, the court wants me to take you to those documents.
Very clearly dealt with you in the submissions.
It is, and I rely on those. And I will simply make one submission at the end, the main submission, why we say the judge fell outside of the margin of discretion, which we recognise as wide and was afforded to him. And so our written case, as my Lord Conworth has just said, is at MS 2805. The trial judge's judgment deals with this issue in paragraphs 112 to 118 at MS 2962. The Court of Appeal rejects the argument based on exhausting ADR, and they stated that the claim ought to have been issued at the latest when the LGO's decision was judicially reviewed in the early part of 2012, around about January. That's paragraph 84 of the judgment at MS 2912. And they also found that prejudice had been caused by the unavailability of evidence from the appellant solicitors and on the police. That's paragraph 86, MS 2913. Although, of course, I do recognise that the learned president didn't feel that he needed to explore whether the trial judge had gone beyond his wide margin of discretion. And section 7.5, which sets the limitation period in subparagraph A, is at tab 73. It's a limitation period of 1 year. The power to extend, if equitable in all the circumstances, in subparagraph B. The authority at tab 36 is done in parole board. At Court of Appeal, the court has a wide discretion and it is not appropriate to attach more weight to any one factor over another. Paragraphs 30 to 32, MS 907. One point which I wish to draw from that judgment, even if there are concurrent claims in contract and tort, Parliament has provided a one-year limitation period for human rights claims. That's paragraph 39, little Roman numeral 8 at MS 912. The issue came before this court, and my lady Baroness Hale was sitting in that case. Rabone and the Pennine Care Trust, tab 47 of the authorities bundles. Lord Dyson, approval of the Court of Appeal's approach, a wide discretion, but nonetheless some factors identified, and the ones that we rely on, paragraph 76 of the judgment, the length of the delay, the reasons for the delay, and the cogency of the evidence. And I just mention in passing that in that case, this court did review the discretion of the trial judge and of the Court of Appeal's decision, which had upheld that decision, and it substituted its own finding to, in fact, extend time in respect of the unfortunate facts of that case, which involved a suicide. My ladies, my lords, the delay in this case was significant, nearly 6 years. In that period, both social workers, Kira Toll and Coolband McCaughlan, had left the employment of Hackney. And the one name that came up in the documents yesterday, Sue Morris, was no longer with Hackney either, and she couldn't be found to give evidence. The chronology at MS 2740 is perhaps one document that I would like to take you to. It's the agreed chronology at the back of the statement of facts. I say 2740 because I only need to pick it up around about I beg pardon, I picked up my learned leader's copy. 5th of October 2007, around about the time that Mr. and Mrs. Williams start the complaint process to Hackney internally. 7th of October 2009, a Stage 2 investigation officer and an independent person meet Mr. and Mrs. Williams to ask them specific questions about their complaints. And the statement of complaint is done on the 27th of October 2009, 269 to 273, MS 346. The investigation officer and the independent person's report at Stage 2 is at 274, MS 3151. That occurred on the 14th of December 2009. Now, there is one complaint within the large number of complaints that were made, which related to the refusal they said, return the children after consent had been withdrawn. That, throughout the thread of the complaint, is complaint number 3. And the finding of the investigation officer is at MS 3191. That finding was partially, the complaint was partially upheld, and the recommendation made for the provision of information leaflets. And that continues throughout the next stage. 16th of March 2010, the appellants, unhappy with the Stage 2 investigation, issue a Stage 3 complaint. That's 329 to 335, MS 3206. The report of Stage 3 is delivered on the 25th of January 2011, 336350. That is at MS 3213. And specifically in respect of complaint 3, the finding is at MS 3221, and the recommendation of Stage 2 is upheld. Over the page, on the 3rd of February 2011, the internal statutory complaints process terminates. That's MS 3226. Now, it's important to specify in my submission, in our submission, that Hackney's direct involvement in this complaint ended at this juncture. Any saving of resources that could have been had through a fact-finding exercise and through gathering the view of Hackney itself came to an end on the 3rd of February 2011. And the appellants were not content with the outcome of Stage 3. They issued a complaint to the local government ombudsman. And from that moment on, the complaint became a maladministration complaint. Whereas, of course, this court would have noted from our submissions and from the documents that what we have here has always been a damages claim. The initial decision of the Ombudsman is given on the 11th of October 2011 at 368 to 382. That's MS 3245. An important point, complaint 3 is repeated and the findings, the internal findings of Hackney are upheld. No further recommendations are made. Complaint 3 is at MS 3250. A request is made by the appellants for that decision to be reviewed internally. That happens on the 15th of February 2011, and the decision is upheld. 383 MS
12, that must be, mustn't it?
I beg your pardon?
15 February 12, it must be, mustn't it?
Yes, that's right.
Very well.
My Lord Royston, I'm grateful for that. It is. And this is what happens. By that time, in around January of that year, Mr. and Mrs. Williams had already issued a JR claim slightly out of time, but that didn't turn out to be determinative. The permission is refused on the 15th of March 2012 on paper. That's at 3261, MS 3261. They request an oral hearing, which takes about 3 months to list. The matter comes before Mr. John Howell, QC, where he gives permission on one ground only. That's 13th of June 2012, internal page 385, MS 3262. The judicial review, in respect of ground, the only ground on which permission given is compromised. That is not a decision to which Hackney is a party. The local government ombudsman accepts to conduct oral interviews with 3 of the 2 social workers and the chair of the Child Protection Conference. And pursuant to that consent order, interviews take place. That, of course, has the result of further delays. By that time, the social workers had left the employment of Hackney. And then, having conducted the interviews, the local government ombudsman issues a revised decision on the 24th of April 2013, about a year later. That is at 405 MS 3282, and the crucial finding here at MS 3292 is that the LGO officer, what she says in her letter 3292, is that notwithstanding the interviews that she had conducted with the social workers, she is not in a position to review or change her decision. That is the decision of the prior of 2011. And so what she says is that the allegations of fact and of misconduct that are made are denied by the social workers, and those disputes are not one that the LGO can determine and resolve. And that finally leads to Mr. and Mrs. Williams accepting that the only course is to come to the QBD general list, and the claim is issued on the 1st of July 2013. Now, as against that background, my lords and my ladies, can I ask you to go to Sir Francis QC's judgment at paragraphs, starting at paragraphs 115, which is MS 2962.
I should warn you, you're already over time.
I'm grateful.
No, you shouldn't be grateful.
For that warning, but I will now take it very quickly. Appendix 1, 2962. What we say is that the judge errs in his findings. He goes beyond his margin of discretion. In paragraph 115 of his judgment, He states that it was reasonable for the appellants to have waited for the outcome of the LGO complaint, but his error is that he doesn't state what difference the outcome would have made to this claim. He finds that there's an overlap between complaint 3 internally to Hackney and the LGO and these proceedings. But that must be wrong, we say. That's not a finding that he could have made, because the outcome of the complaint could not have determined the disputes of fact. It was not binding on this court, and the complaint procedure would never have given the remedy of damages that these appellants were seeking in proceedings. And importantly, it would not have achieved the closure that they wanted. Even if some of the investigations could have saved resources and possibly informed the appellant's decision about whether or not to issue QBD proceedings, the prejudice to Hackney is that it lost all control over timescales once the matter was referred to the LGO. It was entirely at the mercy of third parties. And when the LGO issued her first decision, the appellants elected to pursue litigation, but they deliberately elected to issue a JR claim against the LGO. And therefore we say that on any basis, there's no legal justification for the deliberate decision not to issue these proceedings, at the very latest within 1 year of the first LGO decision. That is slightly more generous than Lord Justice Leveson, who would have found that they ought to have issued within, I beg pardon, Lord Justice Leveson was slightly more generous. He would have given them 1 year from when they actually issued the LGO claim. That is, in essence, where we say the judge erred, because he placed undue influence on the reasonableness of awaiting the outcome of the litigation, when in fact, the complaint, when in fact, the consistent outcome in respect of complaint 3 had never changed. And to make weight arguments, if I can put them that way.
I think you must stop now.
Very well, I'm very grateful.
Your learned leader didn't give you enough time to do everything
Well,
you wanted to do, but we have to leave enough time for everybody else
Absolutely.
to do what they want to do.
In that case, I simply defer the court to our written complaint.
Yes,
I'm grateful.
Thank you very much, Mr. Sinai. Thank you.
Ladies, my lords, together with my friend Mr. Lang, I appear on behalf of the Association of Lawyers for Children. And may I begin by thanking the court for permitting the association to intervene in this appeal, and particularly for the permission that's been extended to us to add a few words to our written case, which appears in the court bundle from page 2834. The issues which are engaged on this appeal are encountered regularly up and down the country in a wide range of practically different situations by solicitors with the conduct of childcare cases. But it's perhaps for those who do not have the benefit of a solicitor's advice for which the association is most concerned, and for which the association wishes particularly to intervene in this case. Just by way of a reminder, if I may, before I come on, and I would like to concentrate, if I may, on two arguments, looking at Section 20 and the interpretation of it, and secondly, the interplay between Section 20 and parental responsibility. Before I do, if I may, just a reminder that the majority of children who enter the care system do so via Section 20. The latest figures we've identified from the Department of Education to the end of March of last year demonstrate that more than 17,500 children did so via Section 20 in that year. And we say that those numbers alone make a good case for seeking clarity from this court, if this court is able to provide it, and, if it can be, simplicity when understanding the meaning and the effect of Section 20. Because, of course, those issues that arise under Section 20 affect the most profound, or one of the most profound decisions a local authority or a court is called upon to determine, and that is the question of the separation of a child from their family.
Could I just ask you, it's relevant in a sense, we were reminded a moment ago that the Ombudsman recommended that Hackney produce a leaflet. Indeed, I upheld the complaint. There hadn't been enough information. I just wondered whether we've got that leaflet. If not, maybe we could be provided with it.
Well, my lord, perhaps that can be provided. I don't have that leaflet, but what I can say to my lord, if this assists, is that in fact, until the Court of Appeal decision was handed down, the system was working rather well. according to the guidance that was given by no less than the President and other judges of the division. And so this decision of the Court of Appeal has rather somewhat drawn the rug from under a system that was working rather well. So I wouldn't be surprised if there was a leaflet, and I wouldn't be surprised...
Well, no, I mean, I was assuming that authorities would produce leaflets following the guidance the courts have given.
Lord, I would hope so, and I would assume and hope that those leaflets would focus upon the guidance. And of course, the difficulty, as things stand at the moment, is there is...
What guidance do you give?
Well, it's not really a question for you, what Hackney did in response to the...
No, I just raised because I wanted to.
However,
raise
we've got such limited time, I'd
Yeah.
like you to be able to get on with your...
Thank you very much. And so, in relation to this decision as to how to interpret Section 20, can I just, by way of example, draw attention to the practice and the theory by reference to an argument that was raised yesterday with my Lady Black. That was in considering Section 20, subsection 7, and the question the respondent asked the court to consider is whether or not the challenge should be brought by way of judicial review, so that if the parent takes issue with the decision of the local authority under subsection 7, then there lies the remedy. And of course, the court reminded the respondent that the perhaps more practical remedy was simply to remove the child under subsection 8. But of course, the parent and the parents with whom one deals in these cases may not have been told of the local authority's objection, may not have been told of the right to remove, or if they have been told, may be fearful of exercising the right to remove. And so whilst there is in practical terms a simple answer, or in theoretical terms a simple answer, in practical terms it may not be put into effect.
Mr. Twomey, I think this is an appropriate question to put to the association. Is there legal aid under the legal aid scheme for advice to parents when there is a proposal to accommodate their children under Section 20 or to continue with accommodation under Section 20?
Not per se, no.
What do you mean by that?
There is. I have an experienced solicitor behind me. May I just check?
At some stage, I think it would be helpful.
I believe in the, as it were, pre-action protocol, when care proceedings are envisaged, at that point, what might have been called green form advice, preliminary advice can be provided.
Well, that's certainly not the stage that I'm talking about, is it?
No, my lord.
If you could come up at some stage before the end of the hearing with an answer to that, it would be helpful.
So, thank you. In summary then, what do we say about Section 20 and parental responsibility? Well, in our written case, we propose, we believe, a different approach to the interpretation of Section 20, different to that advanced either on behalf of the appellant or the respondent. And in particular, we ask the court to consider and to look in particular at subsections 1 to 7 as addressing the local authority's obligations and not thereby impinging on the rights of others, most obviously the holder of parental responsibility for the relevant child. As apart from subsections 8 to 11, which do impinge upon or restrict the operation of parental responsibility in certain circumstances. And in particular, we ask the court to consider how Section 20 impacts upon the common law operation of parental responsibility as refined by the Children Act. Now, this appeal concerns children who had active parents, each with parental responsibility, each saying they wish to continue to parent the children. And so our submissions concentrate on that situation. And we ask the court in summary to consider whether it can provide guidance, firstly, as to the meaning of the phrase, shall provide accommodation. And then if a local authority has the power to provide accommodation, how does that process work? What in legal terms occurs along each step of the way? In particular, the step between the offer or the provision of accommodation and the entering of the child into that accommodation. And how does that impinge upon parental responsibility? And in relation to parental responsibility, we'd ask the court to look, and briefly in oral submissions, to the common law position, the impact of the Children Act, and then how it might operate together with Section 20. So may I begin by inviting the court to look then at Section 20, which is in Volume 6 of the Authorities bundle at tab 70, page 2024. In relation to subsections 1 and 3, these appear to set out mandatory obligations. The local authority shall. So we pause there to say, what shall they do? They shall provide accommodation. And we draw the distinction between provide accommodation and accommodate. And what does provide mean? And we suggest an ordinary use of the word provide, to supply, to make available, to furnish for use, to yield up. In relation to subsections 4 and 5, one sees similar terminology, but giving rise to a discretionary power on the authority. The local authority may provide, yield up, make available accommodation. So by the time we have passed through subsections 1 through to 5, we suggest looking at mandatory and discretionary powers to make accommodation available. But at this stage, nothing has been said about the rights, powers, or at all the parental responsibility holder for the relevant child. And certainly, if there were to be a fettering of those rights, we suggest that that would have to be spelt out. Then,
Sorry, I'm not quite following this. 21 deals with a case where there's no person who has parental responsibility.
20, my Lord, properly draws my attention to the 3 subsections.
Yes.
And
we're in dealing with subsection C, subparagraph C.
Yes, we're only dealing with that, and that's to which I direct.
Which assumes there may be someone with parental responsibilities, so we're not within A, but then says the person caring has been prevented from providing accommodation.
Yes.
And that's what Hackney says the case here, because the parents couldn't provide the accommodation because of the bail conditions.
Well, what I say about each of these aspects of each subsection is that the local authority is to ask itself a factual question, and it is for the local authority moving through from 1 to 6 and 7.
Yes, I mean, I understand that. You may be looking at the matter more generally. I'm trying to relate it to this case.
Yes.
And
so, my Lord, in this case, the local authority asks itself whether it has an obligation, and it looks to subsection 1, and it identifies subsection C as the relevant trigger to that obligation. But that is all it does. It triggers their obligation.
Yes, and so they did
to make it available.
Unless there's an objection, that's what.
Well,
let's move on, shall we? Through your, because you don't have much time.
No, I don't. Thank you, my lady. Well, in relation to subsection 7, may I briefly suggest the court looks, if you would be good enough, at volume 1, tab 18. It's the case of Lady Black in Re B in 2013. For this purpose, attention has been concentrated upon paragraph 34, but in MS page number 362, paragraph 35 is set out. The lady considered the impact of subsection 7 and the argument of the local authority that a duty arose, and because of the objection, they were prevented, for whatever reason, from providing her, from fulfilling that duty, as the parents objected. And then he said this: the alternative is that the joint effect of subsections 1 and 7 was to prevent a duty arising at all. And so what we suggest in our written argument is that one looks at the a list of factual questions, which we've set out in our document at page 2843, paragraph 37, and the local authority asked itself those questions. And if the answer to those questions is yes, then the right to the obligation or the permission to offer accommodation arises. And so we ask this court to consider whether, in fact, the operation of subsection 7 does any more than simply tell a local authority whether or not it has a duty or may have a duty to do something, to offer accommodation. And so, for example, the respondents in argument and in their written case have said, when considering subsection 7, they've spoken of the parent's right to object. Well, that would be to read subsection 7 as impinging in some way on the ordinary rights of the holder of parental responsibility. That, in our submission, is questionable. It's not a question of the holder of parental responsibility having a right to object. It's just a question of fact. Did they object? And if the local authority finds that they did object, then the local authority has decided, if it confirms all the other answers in the affirmative, that it has a duty. But what is that duty? It is a duty to offer accommodation. And in our submission, there's been a concentration on the objection word in subsection 7, as if that impinged upon the rights of the holder of parental responsibility. And so one then moves on through the section 20, to subsection 8, where the issue of removal arises. Can I just very briefly identify the wording in subsection 8 as the right to remove the child, and to remind the court that when it comes to consider the recent argument advanced on behalf of the respondents, two matters. Firstly, in the respondents' own argument, at the close of their argument, at core page 2817, the respondent refers to the parents requesting the return of their child. And of course, if there's a request for a return, then the person receiving the request is engaged in responding to it. And there may be questions of lawfulness as to whether they'd go along with the request. But the statute says the parent may remove. It's got nothing to do with the local authority agreeing or disagreeing. The parent has the unfettered right to remove. And so what we identify is that we suggest that it is clear there's an offer of accommodation made. It's clear that if the accommodation is taken up, the child can be removed from that accommodation. What is not clear is how the child moves into that accommodation. And we say that subsection 8 simply does no more than reiterate the common law position. And usually statute would not simply reiterate a common law position, but it does it here because it then chips away at it by the following subsections. So it sets it out, as it were, only to refine it in the following subsections. Ladies and lords, section 3 defines parental responsibility by reference to the rights, duties, powers and responsibilities which a parent has at law, that is, common law. So unlike Scottish law, there's no self-contained definition. And we have referred the court to the authorities in relation, recent authority of the President in relation to parental responsibility. There is, in a way, there was a dearth of consideration of what it meant, that term. Subsection 9 of section 2, so section 2.9 of the Children Act, and that is set out in the same tab, at the start of that tab, page 2012, tells us that a person who has parental responsibility for a child may not surrender or transfer any part of that to another, but may arrange for some or all of it to be met by one or more persons acting on his behalf. So we suggest that when a child is accommodated, the parent is arranging for some or all of their parental responsibility to be exercised by others acting on his or her behalf. And primary amongst the bundle of rights and powers which exist is the duty to accommodate the child. But there are obviously many ancillary services that go with the provision of accommodation, the extent and level of the services, the extent and level of the intimacy of those services, depending on the age and the needs of the child. The day-to-day obligations to feed, to dress, wash, educate the child are met as an adjunct to the provision of accommodation. And we submit that these must be delegated. So can one really say that the provision of these services to a child for whom you do not have parental responsibility is anything other than a trampoline across the rights of the holder of parental responsibility for that child, unless that person has delegated those duties to you. Otherwise, it would amount to the imposition of services, including intimate services, as well as accommodation. We submit that everything about the provision of accommodation is in the nature of the exercise of parental responsibility in place of the holder of parental responsibility. And so we suggest that the way in which a child who has parents available with parental responsibility enters into the accommodation that is provided by the local authority is, by operation of law, the parent delegating parental responsibility. And that, we say, therefore, can only arise by way of consent. Because in the words of the statute, that person is making an arrangement. You can't make an arrangement where there's no consent. And so if one were to look at the scope of potential options, express consent, tacit consent, neither consent nor opposition, express opposition or tacit opposition, in our submission it's either one or two. There must be a consent because the parent is making an arrangement. And we submit that nothing in subsections 1 to 7 expressly or implicitly fetter the rights of the holder of parental responsibility. And why is consent not, or agreement not mentioned in those subsections? It's not mentioned because it's not about the holder of parental responsibility. We submit it's arguably all about the local authority deciding whether it has that duty. Ladies and my lords, the further support for this argument may be derived, we suggest, from, for example, looking further into section 20, the bottom of section 20 and subsection 9. Subsection 9 says that the right to remove doesn't apply in certain circumstances, and primarily that is where the care of the child is confirmed on another by a court order, whether it be child arrangement, special guardianship, or inherent jurisdiction. But the subsection continues, any person, so described, agrees to the child being looked after in accommodation provided. So the agreement of the superior holder of parental responsibility is necessary and spelt out. It has to be spelt out here because there is a potential conflict. And it's further spelt out in subsection 10 that all must agree. And then subsection 11, 7 and 8 do not apply where a child who is over 16 agrees to being provided with this accommodation. Now, my Lady Hale, we believe, appropriately reminded us that the provision of accommodation is an ongoing continuum. And so it would be peculiar if a child is asked, as the parent turns up to remove, do you wish to remain in this accommodation? The child says yes and agrees. It would be peculiar if at the start, at the outset of the provision of accommodation, the holder of parental responsibility for a younger child should not also be asked, should not also have to agree. We also ask the court to consider really the sense in which Parliament could have intended that there should be an objection which falls short of the conditions in subsection 7, to take the respondent's view of subsection 7. The local authority to say your objection does not stand good, but for the parent to simply turn up and remove the child, and to look at the consequences of that. To follow the argument through, the local authority would be entitled to say again, we will accommodate this child, your objection does not stand good. And so the revolving door scenario identified by the appellants would arise, and that cannot be right. In our submission, that's probably the wrong interpretation of subsection 7, and it makes much more sense to look at subsection 7 as a question entirely for the local authority as to whether or not it has a duty to be satisfied.
But what do you say about the two situations in which agreement is not going to be forthcoming. One is where there isn't a person with parental responsibility around, either because paragraph A of subsection 1 applies, or paragraph B, child's been abandoned, you can't find anybody with parental responsibility, or of course the situation that I raised of the parent who lacks capacity to consent. Now, what do you say in those circumstances? Are care proceedings inevitable in all those circumstances? I don't believe you'll say that.
Not necessarily so. May I take the parent without capacity separately? But
well, that's the hardest one for your argument that agreement is necessary.
Well, yes. I mean, perhaps I can deal with that separately. Very, very briefly with A and B. Mm-hmm. The answer is, under our model that we're proposing to the court as a potential answer, is that the common law rises to fill the gap, so that where C applies, the common law is very clear about parental responsibility, what's involved, particularly the right to accommodate and decide where your child should be accommodated. And what we say is that in relation to A and B, the simple answer is the common law rises to fill the gap. And it's not a huge gap, because we have section 3, subsection 5, which says that if the child is in your care, you may take reasonable steps to care for that child. And so routinely the child might already be in the local authority's care. And so we would look to the common law to come up with a common sense answer, which is, there's a child who fulfills A and B. Is it doing more than simply prompting the child into the accommodation, to say that removal of the child into the accommodation is doing something akin to the statutory section 3.5, doing what's reasonable. The same could then be said about the parent who lacks capacity. The common law must come up with an answer for that. It could be said, perhaps, that the parent who lacks capacity is not able to exercise parental responsibility and should be considered as a situation. But may I say one thing in relation to that? If one looks at the advantages, as it were, and disadvantages of the issuing of care proceedings, the disadvantage is clear. It's costly, it may be frequently required, and of course it might be right to say that the child might be a child in need, falling short of threshold under section 31. So I readily concede those points. However, if a parent cannot agree to a child being accommodated, it's very likely they can't oppose it, and it's very likely that they can't remove the child. And so there is the risk that it will endure, that is, the decision of the local authority to precipitate the child into care, will endure for longer than appropriate. It's likely that that parent will be a vulnerable parent. And of course, one contrasts the role of the position, standing of the position of that parent in relation to care proceedings, where that parent would themselves have a guardian ad litem, the official solicitor, routinely, and a case is advanced on her behalf. And of course, in that case, it may be that the parent wouldn't understand that the child has been removed by operation of law, or even fully understand the decision. So there may be good reasons, in fact, for the common law to say that in that situation we don't look at A and B, we say there must be the issuing of care proceedings. But I think the simple answer to Milady's question is that where there is the gap between the provision on the one hand and the child in the accommodation to be removed on the other, the common law fills the gap. And in the case of holders of parental responsibility, that's well established, we suggest. May I just check the position in relation to public funding before I
Please.
ask if there's anything else I can assist with? Very grateful, thank you. I'm told that the answer will be provided by Mr. Verdon, Queen's Counsel, and if necessary we can provide a written document to deal with that. I should have said, and I'm helpfully reminded, we do have a copy of section 21, it's the next section after 20, and that deals with the case of a child who is brought into accommodation as a consequence of, amongst other things, police protection or remand. And that refers to the obligation on the local authority being to receive and provide accommodation. And of course, I learned yesterday that Section 2 of the Child Care Act similarly put an obligation on the local authority to receive. and we are not here.
Oh dear, you're all so young these days.
Probably quite a good way to end. But if there is...
You say you've got Section 21.
we have it and we can circulate that. And finally, Re-N was raised in argument yesterday. Had the advantage of being senior counsel in Re-N and acting in the lower courts in Re-N. There's little reference to the factual circumstances surrounding the Section 20 issue because they were in dispute, and so they were not set out in the Court of Appeal's judgment, nor were they germane to the decision. But I can tell the court that in that case, the two children, little children, there was an application for an emergency protection order, which precipitated an attendance at court whether an agreement was struck between the parents, legally advised, with an interpreter, to agree to Section 20. It was written out, and the Section 20 being the imprimatur of the court seal that went with the court order that made no order on the application for the emergency protection order. The way things were done properly and have been done properly, and the way things that the way solicitors up and down the country have understood that they should be done. So may I make this final respectful request that maybe, if possible, please have guidance for clarity in relation to this issue of Section 20 for the benefit of the many children who enter Section 20, enter care via Section 20, those who have to advise them, but particularly for those who have nobody to advise them. Lady Milord, is there any other matter?
Could I ask a question?
Of course, yes.
Very quickly, Mr. Toomey. A child is accommodated and placed in foster care. The mother with parental responsibility turns up at 8 a.m. on a morning outside the foster home and demands the child back. Is the local authority, who is minded to resist this and take proceedings for an emergency protection order, entitled for the next few hours, in law, not to return the child, pending the taking of proceedings?
But we think not. We think not. We think the practical answer is that the police are called.
Sorry, I can't hear you.
Sorry, my Lord, the answer to my Lord's question is we think not.
And the police are called? What can they do about it?
Take the child into police protection. And they would,
If the grounds
are
for
made
doing
out.
so exist.
I mean, as a newcomer to this field, that sounds a bit odd, but has this been considered in any of the cases, or is this just the assumption? I mean, in this case, the solicitor took the very sensible view of giving some time, and we've seen what happened, but...
We think there is some guidance from the President in one of the cases in our authorities bundle. Perhaps we can have time to identify precisely which passage of which authority we wish to refer.
You say call the police. The social worker calls the police. The police don't come for 3 hours. Is the local authority entitled for those 3 hours to resist the removal of the child?
But we would say not, that there cannot be avoidance of the statutory scheme.
That's very unsatisfactory, isn't it, Mr. Twomey?
In practice, of course, the social worker won't be there.
No.
They turn up at the home. So it's the poor old foster parent who's got the difficulty as to what to do.
I suppose the answer, sorry.
But we're only positing a case where there are reasonable grounds to believe that the Section 31 criteria are fulfilled.
Yes.
Because those are the only circumstances in which it would be proper
Yes.
for anybody to resist the removal of the child.
Yes.
So there probably is somewhere somebody has said something sensible about what to do if there really is serious cause for concern.
It may be that Section 3.5 would assist in that situation. So that it would be reasonable to take the step of, so an intoxicated parent turns up.
Yes. I mean, it's rather like the emergency medical procedures
Yes.
situation. That's one way of it.
The more common situation is someone turns up at the school after an allegation has been made, a serious allegation has been advanced by a child to a teacher, the parent gets wind of it, turns up to demand the return of the child, and I suppose in those circumstances then subsection 3.5 comes to the aid because the child is in the care of the teacher, the foster carer, whoever, who could justify their actions on the basis of section 3.
That sounds like a neat answer, but 3.5 gives the person who's caring for the child but doesn't have parental responsibility the power to do what is reasonable, subject to the provisions of this Act, Mr. Twomey. So,
Yes.
can it trump 28?
Well, that's why my instinctive answer was no.
Does the law ever tolerate unlawfulness?
Well, that's, of course, another question
Big question.
in relation to unlawfulness. Yes.
I mean, I think the answer is either that subsection 5 applies, or there is some helpful guidance which we can identify, or the child is simply permitted to be removed.
Or perhaps we should add to the helpful guidance.
Well,
That, of course.
Thank you.
thank you very much indeed, Mr. Twomey. I should say that faced with 4 applications to intervene from interested organisations and responsible organisations, we took the view that it would be sensible to allow oral submissions from one that was coming from the point of view of the children and one, the family rights group, that was coming from the point of view of the families. We had no idea what your actual argument was going to be at that stage. So it wasn't a question of stacking everybody up against the local authority or anything like that. Please do not think that was the case. It was simply, we thought, the wider perspective of these responsible organisations would be of some help to the court. So thank you very
I'm
much.
most grateful for the opportunity.
Would you prefer to go on till 10 past so that we can finish?
10 past 1?
Yes.
Yes.
Would you be prepared to go on till 10 past so that Mr. Bodell can have...
Could I do? Would you be prepared to?
We'll go on till 10 past.
Thank you very much, my lady.
10 past on my computer, which is...
I'd already given 5 minutes of my time to Mr. Twomey, confident that our oral submissions would probably take 20 to 25 minutes.
Oh, well, that's fine then. Thank you.
My ladies, my lords, firstly, the Family Rights Group is also extremely grateful for the opportunity to make submissions in this appeal. I represent them together with Mr. Edwards, Mr. Guinness and Ms. Kumar, who sits to my right. You have our written submissions at 3350. You will know, of course, but for the greater audience, the Family Rights Group is a registered charity that provides advice and support for families whose children are involved with social services. As per this court's direction, our arguments will not argue for a particular outcome in this appeal. The intervention, as you will have seen from our written case, is on the basis of the charity's experience generally as to how Section 20 works in practice, and therefore the intervention doesn't engage with the specific and somewhat unusual facts of this case, in particular given the bail conditions, but does attempt to assist this court by providing a general context. I would endorse completely Mr. Twomey's plea to this court to provide guidance. The Family Rights Group says guidance is desperately needed. And I would say the oral submissions you've heard so far have shown that disagreements exist, there are complexities, and there is confusion as to the interaction between the subsections. My lady, the court knows that in 2016 to 17, the Family Rights Group undertook a wide-ranging inquiry into the current use and operation of Section 20 and produced the Knowledge Inquiry. This detailed piece of work forms the basis of our written case. MS 2166 is the reference. Based on that work and its experience generally of Section 20 cases, the Family Rights Group's position in this appeal is as outlined in paragraph 14 of our written case, 3354, namely as follows. Families who often do not have legal advice, I'll come to my Lord Wilson's point in one moment, do not understand their rights and options under Section 20. Secondly, current guidance offers little assistance as to the meaning of Section 20. Thirdly, parents but also professionals are somewhat confused about Section 20. Fourthly, that social work and local authority practice in respect of Section 20 varies across the country. And fifthly, a point which will not have escaped this court's attention, there is limited scrutiny of Section 20, given that it falls, generally speaking, outside of the court process and given the limited legal aid available in such situations. And may I address my Lord Wilson's point briefly, but we would be very willing to provide a short, concise written submission on this issue if it would assist this court. In theory, legal aid, legal assistance is available pre-proceedings, pre-care proceedings to parents whose children have been accommodated under Section 20. In other Section 20 cases, again, in theory, some legal help is available to those parents, but it's means and merits tested. And certainly the experience of our instructing solicitors, Goodman and Ray, who are extremely experienced in this field, say it is rarely taken up. The practical situation the Family Rights Group tell us in their document is that although technically it is there, it is very limited in scope, legal aid I'm talking about. Many solicitors are in fact not taking on this type of work because of the administration and the poor remuneration. And that is perhaps why the advice line which the charity offers is, they would say, inundated by questions and queries from families involved in Section 20 accommodation cases requesting advice and assistance. And that's dealt with in full detail in the knowledge inquiry. The key points which the Family Rights Group would wish to emphasise through me at this point are number one, the breadth and nature of Section 20. Number two, the importance of fully informed decisions based on information sharing. And number three, the relevance of exploring care by the wider family and or family friends. Firstly, the breadth and nature of Section 20. This is an extremely important provision. You've already been given statistics in relation to the number of families and young people affected. There's been a focus on Section 20 as a precursor to care proceedings, but you will know from the documentation that in fact it has a much wider range and a much wider use. And the Family Rights Group would say that at its best, it represents a voluntary collaboration and partnership between parents and local authorities. Paragraph 16 of our written case, MS 3356, refers to the numerous examples of this broad provision in practice, which includes, but is not limited to, the following situations. Short-term respite care for families who are struggling to deal with a crisis. Short breaks for children suffering from suffering from disabilities. Longer-term care for children with disabilities, the placement of children with family and friends, care for homeless young people aged 16 to 17 who require accommodation, children returning home from local authority care, children beyond parental control, abandoned children, asylum-seeking children, and even, in some cases, children in foster care who are then placed in adoption placements. So this court will immediately appreciate its huge significance. May I say a word about statutory guidance, which is covered in various of the parties' written cases. Statutory guidance is extremely important and helpful to social workers. The local authority in this case agree that it should be followed unless there are exceptional circumstances. That's paragraph 49 of their case, MS 2796. The historic statutory guidance, which you were referred to yesterday by Ms. Fottrell, remains in place with its emphasis on cooperation, partnership, and the voluntary nature of it. However, the charity's experience is that social workers are not referring to this, and if the court could clarify its status, that would greatly assist.
Could I just ask you something? You may or may not know the answer to this, but it's been puzzling me because there used to be regulations. In 1991, there were arrangements for the placement of children, open brackets, general, close brackets, regulations, which actually put flesh on the bones of some of that guidance. But I gather that they're no longer in force. So have they been replaced by anything?
My lady, I don't know the answer to that without checking. I'm not even sure if those regulations are in the appendix.
Well, there's no reason why they should be if they're not in force or weren't in force at the relevant time. However, I'm tossing out the question. There are lots of lawyers in the room, and they will find me the answer to it.
Can I just ask you on your last proposition, you want us to help on the legal status of the guidance?
My lord, yes, please.
What do you say is the legal status of the guidance?
That we agree with the local authority on this point, that it should be followed unless there are exceptional circumstances.
By reference to Section 7 of the
Exactly.
Yes.
Exactly, my lord.
There's plenty of law in relation to homeless people on that.
My lord, exactly. The practical difficulty that the charity identifies is that their experience of working with social workers and the social workers who contributed to the knowledge inquiry would suggest that social workers are now referring to working together in its various guises, and the most recent version of working together is due to be published in April 2018, in a few months' time, following a consultation. And I am led to understand that that document makes no reference to Section 20 at all. And yet that is the document which social workers are now going to when they're looking at issues of working with families and partnership.
Yes.
And so if this court could send a very clear message that the statutory guidance remains in force.
Well, the statutory guidance is under Section 7 of the Social Services.
Yes.
Isn't it?
And that's referred to in the local authority's written case and also in the appellant's written case.
You don't actually have that section, I don't think, do we? But, it's fairly familiar, so I should...
I have the reference to it. It's paragraph 49 of the local authority's case, MS 2796, and there's a footnote on that page which refers to Section 7 and where one can find it.
Okay.
I hope that helps. The charity's central point is that whatever this court decides on the issues of consent and objections, which in some ways are two sides of the same coin, the real issue is that the parents involved in such a process need to be making fully informed decisions based on proper and full information. And that lack of information that is provided to parents, particularly at the initial stages of accommodation, was a key theme identified by respondents to the knowledge inquiry, and I'd refer this court to paragraph 5.5.4 of it, MS 2214. It is of note that practitioners responding to the inquiry also felt that insufficient information and advice was available to parents about voluntary arrangements, and also thought that providing information to parents in any event wasn't sufficient on its own, as proper explanation was required. And the point is illustrated in this case, perhaps by looking at two issues: written agreements and Section 28. The written agreement in this case, this court was referred to yesterday, MS 2969. To make a general point, may I refer this court to the Knowledge Inquiry's investigation of this issue of written agreements. You can find the detail at MS 2206. In summary, the Knowledge Inquiry made freedom of information requests to all local authorities in England and Wales so as to examine what type of agreements were being used in Section 20 cases. About 50 local authorities responded, and based on those responses, we can say that the agreement in this case is fairly typical, in that it is very short, it doesn't deal with the key points such as Section 28, it doesn't deal with the type of accommodation which is being offered and which subsection is being acted on, and it doesn't provide specific duration, for example, of the accommodation in question. Some of the agreements that were looked at were wrong as a matter of law, and, for example, specified the duration of the accommodation, stating that it would last for X period of time, and stating that notice was required to bring it to an end. So there is, again, need for guidance from this court in relation to the legal basis for any accommodation. Some local authorities used information leaflets in response to my Lord Conworth's earlier observation, and some used pro forma letters. But again, the FRG took the view in the inquiry that the majority missed the key points. The recommendation of the knowledge inquiry was that there would be much use of a national template, which, not a model agreement, because obviously each case is different, but a national template that social workers could refer to so that they knew exactly which points to discuss with the parents and which points should be included in the particular agreement in question. All of that can be found, as I said, at MS 2206 through to 22 MS 2229. Section 28 has been much discussed so far. The Family Rights Group's view is that this section may not be a sufficient safeguard, despite it being on reading unqualified, although we've heard what the local authority have suggested this morning. It's an obvious point, but a very important one. Parents can only exercise their rights to removal if they have the information, know they're entitled to remove, understand the implications, and can make those decisions. They need to know that it exists, how to do it. Is it a simple request, or is it physically turning up and acting on a wish? They need to understand that no notice is required. That's what the subsection says. And in response to my Lord Wilson's observation yesterday afternoon, perhaps the lack of a notice period in this statute, not even 48 hours, may have been deliberate and may underpin that these provisions are voluntary and the local authority has no right to keep the child accommodated if the parent exercises its Section 28 right. We'd ask this court to consider that point. So Section 28, on the face of it, provides the protection to families, but unless there is full information in respect of it, unless they really understand Section 28, the Family Rights Group would say, doesn't work. It assumes that they understand exactly its position. May I say a few more words about informed decision-making? Paragraph 79 of the respondent's case, MS 2803, boldly states this: once a social worker correctly assesses parents as having capacity, there should not be additional duties of full information and fairness, provided the parents with parental responsibility understand that they are agreeing to their children being accommodated by the local authority. With respect to the local authority, the Family Rights Group would say informed decision-making does not begin and end with capacity and is an ongoing process. And the knowledge inquiry emphasises the need for ongoing information sharing in relation to not only the initial information, but also the development of the case. The stark reality of a lack of information sharing and informed decision-making is that there are few alternatives available for parents and families other than the complaints other than a complaints process. The family rights group's view is that judicial review is not a practical option for most families, not least because legal aid is not readily available, but also because the process is A, more complex, and B, somewhat binary. It is not a process which is best suited to look at welfare. The children's interests are not a consideration, let alone a paramount one. My ladies, my lords, regardless of how the law is settled in respect of the issue of whether consent is a relevant principle in relation to Section 20, the Family Rights Group submits that the following pressing questions need to be addressed. What constitutes an appropriate approach to information sharing and sufficiency of information sharing where a Section 20 arrangement arises? And what are the standards that need to be met? What are the prerequisites for informed decision-making by parents in the context of Section 20 arrangements? I feel obliged to deal with my Lady Hale's fundamental question posed yesterday. Is Section 20 appropriately used where parents lack capacity? To bring to this court's attention the Knowledge Inquiry's own view, which can be found at MS 2232, and its conclusion, and it's in far more detail at that reference, but I will give this court the headline. Its conclusion was that Section 20 was not appropriate where a parent lacks capacity to enter into a voluntary agreement. My lady, may I touch on the relevance of exploring wider family and friends? We fully appreciate that the issue of a placement with extended family was not important in this particular case, but the Knowledge Inquiry makes clear there is insufficient consideration given to kinship care arrangements in the context of removal of a child from parental care under Section 20. That's MS 2197. It is important that wider family members are identified and involved as early as possible when considering Section 20 arrangements, and this does not appear to be routinely taking place. And if this court can say anything about that issue, the Family Rights Group's view is it would be extremely helpful. May I finish with an answer perhaps to Lady Hale's inquiry yesterday as to whether or not there is a police form for police protection. I'm grateful to Ms. Daly and Ms. Kumar who have identified the relevant form, which seems to have been issued pursuant to Home Office Circular 17/2008. That circular says when an officer takes a child into police protection, he or she must complete a protection form, a police protection form, and we have copies of it here which we can hand out in due course.
Well, thank you very much. That's extremely helpful. Thank you.
My lady, those would be our oral submissions.
Any questions?
No, thank you.
Well, very many thanks indeed, Mr. Verdun,
Thank you very much.
and in particular for completing your submissions by, according to the clock on my computer, which is a little bit slow, I think, 1:02. So the court will now adjourn, and we will look forward to hearing from you further